May it please the court, my name is Collier Initial N, appearing on behalf of the accused George Hoffman. Mr. Hoffman is an intellectually impaired man of the Aboriginal community who lives in Rockhampton. He is being charged with burglary, an indictable offence pursuant to section 419 of the Queensland Criminal Code, a charge, the demonstration of which relies on admissions made by my client. Defence submits to the court an application pursuant to section 590, capital AA, subsection 2, paragraph E of the code. By the application, we seek the court exercise the discretion available to it under section 130 of the Queensland Evidence Act to exclude the Crown's evidence relating to the confessions as made by Mr. Hoffman to Officer Grimes on two grounds. First, under public policy grounds pursuant to Bunning and Cross, where the circumstances of confession and the conduct of the officers far outweighs any benefit to the public from putting away a man unreasonably charged. Secondly, under the ground of substantial unfairness to my client, pursuant to the case of Christie, regarding the prejudicial effect of the evidence relative to its poor probative value. Regarding the first ground of exclusion, Your Honour, we would refer the court to the matter of Bunning and Cross and submit that there was improper conduct before this trial even commenced. The non-exhaustive factors for determining exclusion are 5 in number and well satisfied. It is submitted that, prior to the questioning, Officer Grimes breached section 418 of the Police Powers and Responsibilities Act, the PPRA, by not allowing Mr. Hoffman, a support person, during questioning prior to charging. The police officer further breached section 420, subsection 2, paragraph A of the PPRA, when Mr. Hoffman was not informed that a member of the relevant legal and aid organisation would be notified. Misconduct was ever greater, as the officer breached section 422, subsection 2, paragraph B of the PPRA by proceeding to question my client without a support person being present. On the evidence available, none of this was by mistake. We submit that the evidence was not gathered due to mistake, but through the misleading of Mr. Hoffman. When the police officer said that a friend of Mr. Hoffman dobbed him in, the response in this case was not vital nor perishable. Indeed, Officer Grimes managed to accomplish misleading my client, we submit, but could not even correctly inform Mr. Hoffman of his rights as required under the Police Powers and Responsibilities Regulations, Regulation 2.3, the PPRR. We also submit that the evidence gathered prior to the non-pressing recorded interview was not cogent. Clearly, when Mr. Hoffman stated that I don't know no lawyer to a question generally about support persons, his ability to respond cogently was subject to an impairment. We submit Officer Grimes should have known better. In questioning Mr. Hoffman, Officer Grimes is required, we submit, to ask questions of him to establish his level of understanding, in this case, under the PPRR Regulation 25, Sub-Regulation 1. We further submit that this is not a grave charge, Your Honour, though the defence accepts that it is an indictable offence. Relevantly to Bunning and Cross, there is no element of physical harm. Finally, it is accepted that the officer's conduct towards Mr. Hoffman may be seen as a genuine response to pressing circumstances given Mr. Hoffman's flight. However, on the balance of things, there is a significant call that this evidence, in the interests of public policy, not be admitted. Defence asked the court to exercise its authority to exclude the Crown's evidence as to Mr. Hoffman's admissions, in this case pursuant to Bunning and Cross. Regarding the second ground for exclusion, Your Honour, we submit that the electronic record of the interview that in the electronic record of the interview, Mr. Hoffman can be heard to engage in gratuitous concurrence, when of course the record is audible at all. As is clear from the recording, pursuant to section 9 of the Evidence Act and in the case of Williams, Mr. Hoffman was not competent at the time of the interview, and certainly not now at the distance of time to give an intelligible account of events, Your Honour. Hence, his evidence should be regarded as incompetent, and therefore of slight or insubstantial probative value. We submit that gratuitous concurrence is a problem regarding police interviewing of people of the Aboriginal community in general. When we can hear Mr. Hoffman, we can hear him agreeing with the police, such as a tired yeah, in response to whether he was involved in the alleged breaking and entering. A quiet yeah when tackled, incoherent, misinformed, and asked if he's... A quiet yeah when tackled, incoherent, misinformed, and asked if he used his screwdriver to jammy open the window to enter the house, didn't you? As Barry J. in the case of Mooney and James described, it is a worthless method of examination, gratuitous concurrence. We submit it is generally a worthless method of questioning. that results in it. We concede again regarding Mr. Hoffman's flight that it may be construed as admissible to demonstrate guilt under the case of Edwards. However, the subsequent conduct of Mr. Hoffman, we submit, is demonstrative of simply wanting to not be under the scrutiny of officialdom. This being a cultural problem, as highlighted by Dr. Eads in her report, and thus should be considered as bearing little adverse weight on my client, pursuant to the relevant 1999 New South Wales case of Adam and the Queen. Finally, the real evidence is barely relevant. It is of insubstantial probative value regarding the facts and issue, Your Honour. The mere fact of the existence of the screwdriver and gloves are not rationally related to the fact of, or intent to, be in a dwelling for the commission of an offence. However, combined with the misleading derived admissions, we submit that this potential evidence is substantially prejudicial in Mr. Hoffman, pursuant to the case of Hasler, and of insubstantial probative value, and should be excluded pursuant to Christie. Defence thus asks that the court exercise its authority to exclude the Crown's evidence pursuant to the case of Christie. These, Your Honour, are our submissions that the court should exercise its judicial discretion to exclude the Crown's evidence.